That case was based upon a client that I was representing that had expressed fear of his return back to his country of origin. And not to go too far into it because it's extremely complicated in cases depending on how an individual finds himself into removal proceedings. But the long and short of it was that he was seeking a a fear interview, and he had a fear interview in front of a asylum officer. However, the asylum officer did not find any reasonable fear. However, denied his ability to present a claim under the United Nations. Of course, our argument has always been for years that under the UN Convention Against Torture and the standards that set forth under that UN charter, that UN provision, that a person should be entitled to have, at least based upon due process, an opportunity to prevent that case before a judge. I've got a lot of pushback on it. However, fortunately, at least two of the three judges at the U.S. Court of Appeals agreed with me and published the case, and now it sets that standard.
Let's watch a small clip from the proceedings where reasonable fear of torture is argued.
In this instance, yeah, I would say because he's agreeing with the asylum officer that he doesn't have a reasonable possibility of torture, that you could look to the asylum officer's reasoning in this.
So why wouldn't there be a reasonable fear of torture here with the acquiescence of the government, given that his relatives complained to the government about it, and the government said, we're not going to do anything because we're afraid they're going to kill us too. And he had 5 uncles that are dead or disappeared. Given you need, a 10% chance of torture, and nexus is not relevant here, why isn't this a reasonable fear of torture, even if you're right on withholding?
You have to look to if there's been any torture in the past, and petitioner hasn't lived there in 20 years. He's never been harmed in the past.
I understand he's never been harmed, but 5 of his uncles were either killed or disappeared. Why in a 10% look, isn't it reasonable for him to say, all of my relatives have been murdered, I'm afraid I'm going to be murdered too, and the government hasn't done anything, and my relatives asked the government about it, and they said, we're not going to do anything because they're going to kill us too if we do. Why doesn't that meet the 10% threshold?
Well, they hadn't reached out to government or local police since 2012. There's no recent evidence that the government or the police would acquiesce to his torture. He hasn't shown that they've made any effort whatsoever recently.
Counsel, isn't government acquiescence something that petitioner could show through country conditions evidence, though, that would be something that his counsel could access in a full-blown merits hearing?
Yes, that would be a factor. There's several different factors, whether he could relocate, evidence of past torture, country conditions, and you have to show us a specific threat to petitioner. And he testified that these cartel members they're not even aware that he exists. And he testified that he didn't plan on being a member of the auto defensive group.
But he also testified that the cartels would find out